Well, welcome to Denton's webinar dealing with risks and issues affecting the long-term care facility sector arising out of the COVID-19 pandemic. This is a 1-hour webinar. It is being recorded. We have offered the option of sending in questions ahead of time, and we're taking live questions. So if you do have any questions, feel free to use the chat button on the bottom of your Zoom screen, which you're probably familiar with. I will be moderating it. We're going to hear from 5 speakers dealing with the following areas: health policy, regulatory environment, public inquiries, class actions, and employment and labor. I'm Norm Emblem from the Toronto office, city of the 1967 Stanley Cup champions. And I'm going to turn over the opening remarks to Philippe Couillard from our Montreal office, Senior Business Advisor. He's going to address health policy. Philippe.
It's a pleasure for me to be with you today. I want to give you a few impressions of what's going on around governments in Canada and what we can expect as far as trends are concerned. So we all see that the demography of our Western countries is changing and the change is accelerating. This is something we see in Canada. In general, you could say that as you move east from Ontario, it gets more pronounced, but particularly in Quebec. We also see that obviously, and this is made very obvious now, our society has not yet adapted to not only old age, but what I would call very old age, 90, 95-year-olds. I have an 88-year-old mother who's doing extremely well, but lives in a retirement home, and is quite active. So this is something we will see more and more. And when these people become dependent, they usually become dependent either on physical grounds or cognitive grounds, Alzheimer's and related problems, and sometimes both at the same time. And given the fact that our families have become fragmented in recent years, more and more people are seeking institutionalized care in retirement or nursing home. So the points of view here are quite convergent. The person himself or herself wants to stay home as long as possible before moving in an institution. First a retirement, then a nursing home. And obviously it is a trend that will continue to be supported by governments through various methods, particularly fiscal policy. The healthcare system itself is obviously well aligned with this goal because it just makes more economic sense to keep people at home or in home-like environments rather than large, expensive institutions. We have seen and we will see more of the deployment of technology, both in retirement and nursing homes. Think about remote care, virtual care, telemedicine, monitoring at a distance of patients with chronic disease, which of course will be a common feature of many of the residents of these homes. Governments have been progressively drawn to intervene from the pressure of public opinion and the media in the operation of retirement homes. I think all our listeners are aware of this. Look at the issues of safety equipment, sprinklers, staffing ratios, particularly overnight, looking at people. And after COVID, stability of teams is going to be a very, very important factor. It is now very obvious across the country that provinces such as BC that have barred very fast, very early orderlies from working at more than one installation at the same time are doing way better than Quebec, where this was unfortunately delayed. They will also, of course, now verify pandemic preparedness by the operators, which means the adoption of standardized procedures, drills, and of course, storage of personal protective equipment for staff. We already have seen the announcement in Ontario. There will be more of these public inquiries from sea to sea, coast to coast. There will be even more rigorous legislation, regulation, and standards asked to the operators. Again, this will include pandemic preparedness. New funding models for dependency, age-related dependency are going to be developed, such as exists in other countries in Europe particularly. More financial assistance is to be expected for low-income seniors with stay-at-home incentives. And to be determined, of course, and this is something you're all very familiar with, is how is this extra cost going to be shared between public funds and the operators and you. Next slide. So the trends, if I want to summarize what we see now, is obviously Because of demography, retirement nursing home are a growing market and will remain so. But because of the extra pressures now on safety, equipment, staffing, pandemic preparedness, this will mean a higher barrier to entry for new players in the sector and probably accelerate the trend we've seen towards consolidation of the sector. Public finances will be extremely tight over the next years. So obviously, when new obligations are put in place, the natural trend of governments, the tendency of governments will be to make sure not to take too much of the cost and leave it on the table of the operators. This is something you've seen before and that you will probably see in the coming years. We also will see something that we've seen in Quebec and elsewhere, an important gap in capacity between large urban chain of homes and small rural operators. Now, for the sprinkler issue, this had to be compensated by government financially. How would it happen now? How is it going to be shared? Risk and cost between government and operators remains to be seen. But again, keep in mind the fact that public finances are going to be quite tight in the near future. Thank you. Back to you, Noah.
We're now going to pass the torch to Rose Carter of our Edmonton office, who is going to deal with the regulatory environment. She asked me to ask her a single question, that is, how are the long-term care facilities regulated? Over to you, Rose.
Thank you, Norm. Well, as all the participants know, the government in each of our provinces highly regulates senior residents. Those are called by various names, long-term care facilities, assisted living, but nonetheless, if you're housing seniors, you fall under various statutes. Ontario, Quebec, BC, and Alberta, as I briefly mentioned, have a number of laws, regulations, and standards. For example, in Alberta, we have approximately 13 governing acts, 30 standards accompany those, as well as the necessary regulations. Government, as we have seen reported in the newspapers and talked about in various coffee shops now, have the spotlight on long-term care facilities. There is public pressure being put on government and will continue to be put on government, I suspect, for the safety and well-being of the residents in long-term care facilities. We have already seen government intervention in various instances. For example, Ontario recently issued a number of directives, guidance documents, and other tools to deal with COVID-19. I suspect that this will continue beyond the COVID-19 pandemic that we are currently in. These directives and other edicts, for example, deal with staffing changes. What a staff member can only work in one home now. And there are new regulations and standards dealing with how residents can be admitted and or discharged. As alluded to by Philippe, there is prediction for the future for this decade that occupancy in long-term care facilities will increase by approximately 70%. Given what we have seen in relation to government's responses for the incidents that are occurring during COVID-19, I expect that the spotlight will continue for the foreseeable future on the regulation of long-term care facilities. Thus, I expect that we will see more laws, more regulations, more standards, and much more of a bright spotlight on these facilities. Examples of regulatory requirements, and this is just a few examples. Various legislation have many more than this, from building codes to fire safety, etc. But they all share certain things in common. For example, adequate staffing is expected by governing bodies, safety and security of the residents, spacing, the cleanliness of the residences, the adequacy of cleanliness and the proper attention given to the residents, prevention of abuse, continuity of service, insurance and the adequacy of the insurance. These are just a few of the many requirements our provincial governments demand of owners and managers of long-term care facilities. It is my belief that being proactive may be the best step to take. It is important that staffing updates occur on a regular basis, that managers know the governing laws, regulations, and standards applicable to their the residents that they are managing or own. Thus, we recommend that it is a good idea right now for people to review and update their policies and procedures in the homes. And that means also working with other stakeholders and keeping the lines of communication open, not only with staff, but with residents and the families, reassuring the families and residents that they are being well cared for. The lenders to your institution and all parties and many others should be seen to be your circle of support and those that have to be reported to on a regular basis. You also have to be prepared for the worst case scenario. We've already seen a number of lawsuits, which my colleague will speak to in a few minutes, but we all have to have top of mind the possibility of further public fatality inquiries, which may lead to litigation down the road. So it is very, very important that top of mind be that your policies and procedures and adherence to all the statutes, regulations, and standards be up to date. Thank you, Norm.
Thank you, Rose. We're now going to turn to Lorena Harris, who's going to deal with the subject of public inquiries. And those tuned in will have appreciated that yesterday in Ontario, the Ontario government announced that a commission of inquiry will be held commencing in September. There's already a little bit of chatter in the press that that is something less than a full-scale public inquiry, but here to educate you on the subtleties, if any, between the two is Lorena from Edmonton.
Thank you, Norm. As Norm has spoken to, governments are definitely heeding the call from the public to conduct inquiries into the deaths and issues arising in long-term care facilities. I will start by saying that there is considerable confusion within the public about whether or not such inquiries can assign liability for those deaths. And the answer to that generally is no. But the nature of an inquiry can urge change within the industry. The purpose of inquiries and commissions in Canada is generally to make factual inquiries and then recommendations about what changes could be made in order to avoid similar issues in the future. Most, if not all, provinces have legislation which governs inquiries into fatalities within the province. This legislation governs when inquiries shall be called, the conduct of the inquiry, and the jurisdiction of the commissioner to comment on the circumstances of the death. For example, and I'll speak specifically to Alberta because that's where I am based, the Fatality Inquiries Act appoints a board which shall review investigations under the Act in order to determine the need for holding a public fatality inquiry. And when the board receives an investigation, it reviews that notification or report and may recommendations with respect to any further investigations. And after reviewing the matter, shall make recommendations to the minister whether or not a public fatality inquiry shall be held. Based upon the media reports and the public commentary that we've seen to date regarding the COVID-19 deaths associated with residents of long-term care facilities or assisted living facilities, we are fairly certain that provincial authorities as well as potentially the federal government will be directing inquiries into their concerns. Another example is the Federal Inquiries Act. federal legislation that provides the federal government authority to call for an inquiry and set the terms of reference. There has been considerable media discussion around the call for public inquiries into the management of long-term care facilities as a whole, independent of specific deaths, and the desire for transparency into such an inquiry. We will be seeing the definition of the terms of reference by the various governments, and considerable debate about whether those terms of reference mean broad public transparency into the inquiry or a much more limited focus. That leads me to the question of what we can expect to see. Notice will be given to the operators of long-term care facilities and assisted living facilities of an authority's intention to conduct an inquiry. Typically, the governing legislation allows for interested parties to participate in the inquiry by being represented by counsel, presenting evidence, cross-examining witnesses, and giving argument. The criteria for whether someone is an interested party is contained within the governing legislation. Again, for example, in Alberta, the Fatality Inquiries Act states that persons at a public fatality inquiry may appear, and they give several categories of those people. One of those categories is any person who the judge, on application, determines has a direct and substantial interest in the subject matter of the inquiry. It would be expected that operators of long-term care facilities that are the subject of inquiries would constitute or would be any person who has a direct and substantial interest in the subject matter of the inquiry. Similar considerations may be in place for public inquiries called under the federal legislation. If a facility is the subject of the inquiry, they are given the right to appear and to be represented by counsel. So once the facility has been granted standing to appear, then what? The person presiding over such an inquiry, whether the judge of a court or an individual appointed by a government, generally has all of the powers granted to a court within the province or within Canada. That person can summon witnesses, compel the production of documents, and generally determine how the inquiry is to proceed. This means that preparation is paramount, like any litigation. The long-term care facility must take steps as soon as possible to gather evidence that it determines will be helpful in presenting its case. This means gathering and preserving documentary evidence, identifying and interviewing potential witnesses, and giving some thought to developing its story that the facility wishes to tell the inquiry and the public. These steps should be considered as early on in the process as possible in order to preserve the best evidence available. The facility will have the opportunity to present its evidence to ensure that a balanced picture is presented. The focus must be on policies, training, and oversight. These will be the larger issues as opposed to individual actions of individual employees. Careful attention ought to be given to the selection and preparation of witnesses, just as in any litigation. A witness must be informed about the facility's policies, procedures, and training, and be able to speak to those issues in order to present the facility in the best light. I'd like to make a further comment about the public nature of these inquiries. Consistent with the principle that our justice system is open and transparent, public inquiries are just that, public. What this means is that generally any member of the public can attend and observe proceedings. They may be reported on by the media. The only exception is when the inquiry is directed to be private or closed, which rarely occurs. Parties must generally apply for an inquiry to be closed to the public, and certain criteria must be met before this is directed. I am fairly certain that in the case of the COVID-19 pandemic and long-term care facilities, that there will be considerable pressure to maintain open and transparent hearings, and the chance of these hearings being closed to the public is slim to none. And finally, I'd like to make a comment on the purpose of an inquiry. As noted at the outset, generally the purpose of a fatality inquiry is to make findings regarding the cause and manner of death and to make recommendations aimed at preventing similar deaths in the future. While this means that all those recommendations are disclosed to the public and debated, it does not mean that there is any finding of liability upon the participants. A finding of liability is only within the jurisdiction of the courts, either within criminal or the civil systems. To this end, we typically see that the provincial legislation governing fatality inquiries prohibits any finding of liability. The legislation often prohibits the use of evidence gathered in any inquiry to be used against the party given it in subsequent civil or criminal proceedings. The purpose of this is to promote a full and frank disclosure without fear of that evidence contributing to a finding of liability against that party. Public inquiries, particularly those struck pursuant to the federal legislation, may have a broader purpose. Investigation into business practices and potential misconduct may exist depending on the terms of reference. You will often see plaintiffs or potential plaintiffs and their counsel attending such inquiries for the purpose of gathering notes and understanding the evidence that the facility may have to enable them to better prepare their claim against such facilities. There really isn't much one can do to prevent this in a public inquiry, but it is important to ensure that the facility presents a balanced picture and that the plaintiffs and their counsel do not breach any obligations by attempting to use the evidence that they gather given during an inquiry within the civil or criminal proceedings. And those conclude my comments, so I'll turn that back to Norm.
Thank you very much, Lorena. The only thing I would add to that, which was very helpful, is that the modern inquiry is also live streamed, throughout the country, and the press often pick up on the evidence given on any particular day. So while there's no room for civil culpability or criminal responsibility, reputational risk is very much in play. The other nuance to this is there's a sense when you hear inquiry that all of a sudden it's going to start with the calling of live witnesses. And oftentimes the inquiries are divided into phases where you would have a documentary phase that could take months. And whether or not parties are seeking standing, if you're a player in the industry, you could be met with a broad-ranging subpoena to produce your documents within a finite period of time. So cannot stress enough to be organized and prepared. I'm now going to turn over to Margaret Weltreska of our Montreal office, who's going to deal with the subject matter of class actions, which have already started across the country. More are likely to come, and there's also been individual actions. So Margaret.
Thank you, Norm, and good afternoon, everyone. Over the next few minutes, I will present a summary of the class action proceedings which were already filed across the country against long-term care facilities in the context of the COVID-19 pandemic. And I will also address some risk and exposure mitigating factors which could be taken into consideration both to hopefully fend off and avoid any such litigation in the future. So as Norm mentioned, several class actions have already been filed across Canada, 7 to be exact, 2 in Quebec, 4 in Ontario, and so far 1 in Alberta. I say 2 in Quebec, and I know that my slide refers to 3 class actions, and I will get back to that in a few seconds. But as a preliminary comment, I think based on the allegations and based on of these proceedings and based on what we see in the news, it would appear that for the moment, the class actions have so far been directed at the most severe situations that we have seen, homes which allegedly did not take any of the adequate measures necessary to contain the spread of the pandemic. That being said, we know that, and we see the situation being revealed every day in the news, and it is safe to say, I think, that there will be more coming. The examples of the class actions that have been filed so far, if we look at the 2 filed in Quebec against the CHSLD Sainte-Dorothée and the CHSLD Heron, were really very severe cases and very sad cases also. And the allegations are relatively, quite serious, where we had staff presenting some symptoms of COVID-19, being asked to stay at the premises and being denied requests to go home, and thereby having infected many residents. That's the case of Sainte-Dorothée. In the CHSLD Heron case, staff had essentially deserted the premises because they had fallen sick themselves, and the residents were allegedly left to their own. And it is alleged that at some point there was only 1 or 2 nurses caring for all 130 residents, which resulted in 31 deaths over a 2 or 3 weeks period. In Ontario, similar class actions have been filed, and similar allegations of inadequate preparedness, inadequate response, inadequate not taking the measures required to comply with the guidance that was being issued by the government. Some of the, one example, for example, in the Lundy Manor class action, the home was holding social events and bingo nights with residents several days after the Ontario government had already issued specific guidance with respect to isolation and screening, etc. So as I said, we see that these class actions refer to very severe cases, but we expect more to, unfortunately, more to come. I want to go back to one of the class actions listed for Quebec, the first one on the first slide, which is the Conseil pour la protection des malades versus CISIS de la Montérégie Centre. This is a class action that was filed in July 2018, so prior to the COVID-19 pandemic. It does not yet refer to the COVID pandemic. It is, however, interesting, and I mention it here because this class action was actually authorized already. It was authorized last September. And this is a class action undertaken by Mr. Pilote and the Conseil pour la protection des malades against all CHSLDs in Quebec and against the government for inadequate care, inadequate level of care, inadequate hygiene, insufficient staff. So all the issues that we see now being also referenced in the litigation and in the class actions that are being filed. And considering the very low threshold for authorization or certification of class actions in general across the country, but specifically in Quebec, where it's relatively easy to certify a class action unless it's absolutely frivolous. It is, I think, safe to say that at least in Quebec, the class actions that have been filed in the COVID-19 context will probably be authorized under one form or another, not necessarily for the in the exact form that they are presented now, but chances are high that they will be authorized. What are the allegations and claims from a legal perspective? What is being reproached to the defendants in those proceedings? These allegations and claims are similar and essentially refer to the breach by the respondents of their obligations under the applicable provincial legislation and public health guidelines issued in the context of COVID-19, violations of the residents' rights to personal security and dignity under the Quebec Charter of Human Rights and Freedoms. It is, for example, alleged that the residents in the class actions in Quebec were submitted to inhumane and degrading maltreatment, breach of the respondents' contractual obligations to provide adequate care and safety to the residents is also invoked, breach of the obligation to take reasonable steps to ensure the safety, well-being, health, and dignity of the residents, breach of the duty of care owed to the residents with respect to the management of the homes, as well as breach of the fiduciary duty owed to the residents, which includes duty to care for them and protect them and to act in their best interest at all times. Now, this being said, how does one defend or prevent or prepare for such such litigation. It is, I think, safe to say that many of the allegations will be probably difficult to prove, and the causal link will be difficult to prove for some of the claims. And I think the homes and nursing homes should not and could not be held responsible for not having foreseen or for not having prevented the spread of the pandemic within their facilities, or for not having prevented certain deaths. I don't think this is the standard that they will be held to. However, they can certainly be held liable for inadequate management of the situation. And the courts will be called upon to decide what is adequate and what is reasonable, what is the reasonable standard of care that can be expected during a pandemic. This is a new question that has not been addressed by the courts yet. And it will have to be established and defined. What is that standard in those exceptional circumstances? Obviously, business as usual and the regular standard of care will probably not be sufficient in those unusual circumstances. And the courts will likely look into the specific public health guidance and directives and requirements and orders which were issued by the provincial and federal government regarding screening of visitors, screening of personnel, resident isolation and testing, employee testing and screening, supply of and availability and access to PPEs, adequate infection outbreak planning. So all these elements will be taken into consideration. And we know that those guidelines evolved over time. So the courts will need to look into that and say, well, you know, how fast were they implemented? What was reasonable under the circumstances for the defendants to implement and at what time? So obviously the ability to demonstrate and to prove that immediate and strict adherence to the standards was undertaken and will be key to any defense to COVID-19 related claims. And how does one prove that these measures were undertaken and were undertaken at the right time? I think it is important to document any such steps, and obviously any policies, any measures that are being implemented needs to be documented and dated, and in order to safeguard the evidence, which it is similar to the evidence that Lorena referred to earlier that would be presented in the context of public inquiries as well, to tell your side of the story. It is a good time for performing an internal risk analysis and implementing measures if they're not already implemented to address and mitigate the risk identified. Obviously, any pandemic or crisis plan should be put in place. Employees should be kept abreast of all the policies and guidelines and any modifications to such policies and guidelines in the context of the COVID-19 specific policies as well. Adopt clear internal guidelines on how to deal with complaints, which could arise, whether it's from employees or from the residents, from the clients, that are related to COVID-19, and document those complaints and the responses that were given to those complaints. Be mindful of the importance to protect privilege of any internal inquiries or related to whether to such complaints or other subjects by engaging these internal inquiries through your in-house counsel or through external counsel. in the context of the analysis of defense arguments that could be addressed by defendants, the courts will give importance to the decisional process of the establishment. So decisions that were taken at the right time and in good faith and supported by reasonable arguments should meet the required standard and should not be reconsidered. And one interesting element for Quebec defendants will be the defense that could be put forth through Section 13 of the Quebec Act respecting health and social services, which provides that the right to health services and to social services guaranteed by this act shall be exercised within the limits of the human, material, and financial resources at the disposal of the establishment. So in Quebec, the courts will have to interpret this provision and give it some meaning. And it will be interesting to see how the courts interpret that provision and what does it mean to provide the services within the limits of a human and material and financial resources. When we, and especially in times of pandemic, when we know that the underlying causes of some of the mismanagement of the situation in some of the homes are really the unavailability of those human, material, and financial resources. So this is something interesting and which will be addressed in the first case that I referred to initially, the first class action that was instituted in Quebec in July 2018 and authorized last September. So this is something to follow. And as a final note, a final remark, there is also some discussion and some pressure in other countries. We're seeing in the UK and in the US where similar class actions were instituted against institutions and nursing homes. So discussion for the government to pass legislation protecting the companies from litigation. So it will be interesting to see whether in Canada the same discussion is undertaken, and one can certainly imagine that this type of legislation would not necessarily meet the public's approval, but it will be interesting to see whether it's something that will be considered here in Canada. And back to you, Norm. Thank you.
Thanks, Margaret. What's interesting to me is the press picking up on homes that have acted sooner than others, and plaintiff's counsel will undoubtedly say, as an indication of reasonable care, look at what ABC facility did. They may be in a different province. They may have had more of an abundant supply of PPE. And then that raises a whole issue. How do you get that evidence before the court? You're looking to a third party not involved in the litigation. It gives rise to all sorts of privacy issues. So thank you for that presentation. We are now going to turn to our last speaker, Craig Lawrence of our Labor and Employment group. And we have all been working remotely for, seems like 10 weeks. The employees of long-term care facilities didn't have that choice. And they are the ones that are most exposed to the spread of COVID. And ask Craig just to deal with the labor and employment issues that this sector of the employees in the country have had to deal with and what you see going forward.
Thanks, Norm. So for my time today, I'm going to try and tackle two pieces here that emerge from really remarkable and we always say unprecedented circumstances. Certainly it has been for this sector. The first has to do, I think, with a case that attracted a host of stories and media attention at the end of April. It's the Ontario Nurses Association's application for an injunctive relief against 4 separate long-term care homes, which were managed by Rika Care Centers. And it got a lot of media attention. I think it's useful to unpack it because it speaks a little bit about what the new reality is going to be for the long-term care sector going forward. So what happens in this case? Well, we're dealing with 4 long-term care homes in Ontario. They were particularly hard hit with COVID outbreaks, about 110 cases, 54 deaths. Several nurses had tested positive. Several others were suspected to have had the illness as well. And so what did the nurses do? Well, ONA filed several grievances, as you would in the normal course, alleging that the employer has failed to take proper steps to protect its workers. But it also files an application with the courts for injunctive relief. Now, this is exceptional in the labor sphere because it's fairly rote law that disputes that arise in a unionized workplace are the sole and exclusive jurisdiction of labor arbitrators. So what you would normally expect to have happen in a case like this is the courts to say, look, this is for an arbitrator to deal with. Grievances have been filed. They'll be assessed in due course. And the Labor Relations Act in Ontario, just like the Labor Relations Act in the other provinces across Canada, have expeditious proceedings available to get these questions answered quickly. That's what you would expect to have happen. But the court, given the circumstances, exercised what it considers to be its inherent jurisdiction and actually took hold of the application and addressed it on its substantive merits. And what were those substantive merits? Well, there were really 2 questions that ONA was seeking to have answered. One was were the employers complying with directives that had been issued by the Chief Medical Officer for Ontario Health? And Rose had spoken earlier about some of these regulations, some of the orders that have been issued, some of the directives. And ONA's specific concerns had to do with 1, the access and availability of N95 masks for nurses, and the second being whether or not employers were properly isolating patients and residents that were in their care who had tested positive. And the court essentially says, well, look, these are urgent questions. They're serious questions. It could cause irreparable harm to these nurses if we don't answer it on an urgent basis. And the balance of convenience favors the court answering this rather than waiting for arbitrations to be heard and held. And so the upshot for long-term care homes in the sector is simply that the court, A, exercises this discretionary power in exceptional circumstances, but B, it somewhat shifts the balance of control over PPE itself, because the court essentially says, look, it should be a nurse who's assessing the need for an N95 mask at the point of care to determine whether or not that mask should be made available to them. And that's radically different from how you would typically see a home operate, where the employer is in control of its PPE, it's determining what's necessary and when. And the court in the circumstance is saying, no, it's a nurse who should be able to say, I need an N95 mask, I should have access to that mask. And the employers in this case took an argument that you would think most employers would, which is to say, look, we're managing a scarce resource here. We can't let the personal interests of a nurse overcome the greater interests of the healthcare system as a whole. And the court roundly rejected that submission and essentially said, look, you can't say that nurses who are caring for people who are vulnerable, who are immunocompromised, are acting in self-interest. They are the frontline staff. They are the most vulnerable, and they are entitled to determine when appropriate PPE is required. So again, an exceptional shifting of the balance between sort of core management powers and the union's ability to say, no, we're going to dictate when PPE is used and for what purpose. So that was, a case that attracted a lot of attention, really put the spotlight on the circumstances that were emerging out of the long-term care sector. And dovetailing with that case, we saw the government's changing regulatory model, at least in Ontario, which is, again, I'm using it as an example because it's the jurisdiction in which I practice. We're seeing similar changes in other provinces across the country. And what has the government done? Well, it also is exercising a remarkable degree of oversight and interventionist policies and procedures. So the original order that it issued back in March, I think it was March 23rd, it in and of itself granted significant powers to institute changes and policies with regard to deployment and staffing issues. So that March 23rd order had to do with, look, regardless of whatever your collective agreement says, regardless of whatever a statute or regulation says, every long-term care home has the right to take any reasonably necessary measure to respond to, prevent, or alleviate a COVID-19 outbreak. And that meant changing schedules, breaching CA provisions as necessary if it was required. And that was sort of the baseline, the initial response from the government back in March. And what we saw literally the day after Ona's case, the Reika case at the Superior Court, on April 24th, the government issues an amendment to that order, which takes even more control. And really what it says is, look, an LTC has to have the ability to redeploy as necessary, but more than that, we need the ability to have public hospitals, private hospitals, and mental health care facilities provide assistance and staffing to those long-term care homes. And so what did that really entail? Well, one, it meant that a public health hospital could provide assessments of long-term care facilities. They could provide clinical supervision to the care being provided at those facilities. They could even supply nurses and personal support workers to those facilities, which is, again, a really remarkable step, given that within the long-term care home sector, we were actually prohibited from moving one employee to a different home. And here the government is saying, well, look, the problem has gotten so significant that we're going to let employees from hospitals come into these long-term care homes to provide additional support and services. So again, a remarkable degree of oversight and intervention from the government's part. They also instituted changes to say that, look, that sort of redeployment isn't going to constitute a related employer risk or a single employer risk for those organizations that are relying upon public healthcare employees or public healthcare supervision to engage in their operations. So that was the April 24th piece. And then if we change the slide, Val, what we see on May 13th, so even just last week, the government takes even an additional step. And they say, look, a director on the Long-Term Care Homes Act now has the power to issue a mandatory management order in any long-term care home where there's one positive case. So what does that really signal here? Well, it signals that the government is not taking in any way a hands-off approach. They're simply saying, look, we have the ability to issue a mandatory order that not only can staff from a hospital perform assessments and supervision and literal staffing coming into the facility, we can now order that the corporation or the hospital itself take control over that long-term care home and manage it through the crisis. Again, unprecedented oversight and a radical change in how our conventional labor relations are happening in the sector. What does this mean for us going forward? Well, I think that Margaret has spoken to it. I think that Rose has spoken to it. What we should be expecting is really a radical restructuring of the degree of oversight that the long-term care home sector is subject to, and the degree of integration that we're going to see between public health services and the long-term care home sector. It's going to be a hard thing to walk back, given the degree of oversight and intervention the government has exercised so far. While the government wants to talk about a return to normalcy and the reopening of our provinces, I think the reality is that for the long-term care home sector in particular, we have a long road ahead of us, and the new normal will very well be entirely new. So that's kind of the legislative and case law backdrop of what we've been experiencing for the last 2 months. Let's talk about what we're going to see over the next probably 4 to 6 to 8 weeks. As with many other employers across the country, we're going to be seeing employees coming back to work. While long-term care homes, we were essential services. We had to continue working. Even some of our staff weren't able to continue working, had to provide childcare at home, had to provide for people who were immunocompromised at home. What are we going to do when those people are coming back to work? Well, the pieces that I want to highlight here today are really high-level concepts. One, first and foremost, be cognizant that the accommodation principles that govern most returns to work apply equally here. So just because the province is reopening and just because some people can return to work doesn't mean that some of the additional protections that were put in place don't still apply. So we have to be cognizant of those employees who still have young children at home, particularly when schools and camps aren't open, childcare is not available. We should be cognizant of those people who are providing services at home to the immunocompromised or persons who are otherwise suffering from underlying medical conditions that might preclude them from coming back to work as quickly as we might want them to. And the second part of that is simply to say, look, this has been a mental health crisis as well. And what we need to be cognizant of is paying attention to the mental health of our workers, both those who have been at work and those who will be coming back into an environment that has changed radically over the last few months. We at Dentons have created cross-Canada toolkits for return to work initiatives. They will be sent out as part of this webinar. We also have posted weekly webinar sessions on labor and employment issues that are posted online and can be reviewed after the fact as well. And these are really consolidated national resources. And they're really good sounding points for looking at the weeks ahead of us. As always, the labor and employment issues that are going to arise in your workplaces are going to be context specific, but we'd be happy to support as those issues come forward. That's my comments, Norm.
Thanks very much, Craig. There's time for some questions, including the ones that have been submitted. Philip, are you able to look at the Q&A? One looks like it's suited for you, and the other one looks like it's suited to Craig. The first one for Philip is, do you see any potential to move to a fully public system structure of long-term care facilities, or the continuation of the private sector operation structure supported by provincial funding?
Yes, that's a very good question. What I see is this could happen, the takeover of some homes from government for homes that deal with severely affected people. It's not all the same in the provinces of our country, but at least in Quebec, cases are differentiated among the number of hours of care they need every day. Obviously, the worst cases have been in the sectors where the most heavily affected patients are, CHSLDs we call them, in Quebec, or nursing homes elsewhere. So I think there's going to be a lot of public pressure, and the government already, through the Premier, has talked about this as being a possibility of taking over a subcategory of these institutions that are still fully privately owned and operated, only dealing with severely affected people. So that's a possibility. Some privately owned facilities, yes, in the case of severely affected or severely handicapped or limited patients.
And so the second question from Maureen is, what about the roles of the provincial collective agreements in regulating staffing ratios and salaries? So this is a good question. In Ontario, and there are similar regimes in BC and Alberta, we've already seen, as I just discussed, directives and orders that have been issued under the Emergency Management and Civil Protection Act that essentially suspends collective agreement provisions with respect to redeployment and staffing. So things like staffing ratios, hours of work, those are largely suspended for the duration of this emergency, and employers have much broader discretion to exercise decision-making as they see fit. As I said, the government now has an even heightened role in terms of being able to issue mandatory orders and taking control of those LTCs. But in terms of what to expect going forward, I tend to think what will happen is, as part of the larger regulatory structuring, you're going to see the provincial governments looking to reopen broader provincial agreements to try and address things like staffing ratios, things like the ability to acquire and distribute PPE. Those reopener clauses will probably have to happen, because you'll need either legislative action that overturns on a permanent basis what some of those CAs say, or you're going to need some sort of consultation process where those changes are agreed to between the large players in the sector. All the more reason to get engaged in your province in these sector-wide discussions as to what should the new reality be going forward. But in the short term, it largely means that staffing ratios and things of that nature are suspended.
If anyone has any questions relating to any of the subject matters covered today, feel free to reach out to any one of us. We'd be delighted to respond. Thank you.